Morning, everyone. I'm Judge Jackie Powell. This is First Appearance Court. Today, I'll let you know if I've determined probable cause, and then we'll also talk about release conditions. I encourage you this morning not to talk about your case on the record before consulting with your attorney because everything in this courtroom is being recorded and can be used against you at a later time. So if you're represented by counsel from the Public Defender's Office, or if you have private counsel, you may want to speak with those persons before saying anything on the record. You also need to know that in the courtroom, I do have an attorney from the state attorney's office, as well as confinement status, pretrial supervision office, and the clerk of court, and those persons are able to provide information relevant to your case. So today, I'm going to call each person individually. I'm going to ask you to step up to the podium, and then we will be able to address your case. And before, Mr. Reedy, has the jail asked for anyone to be called out of turn?
Yes, they have, Your Honor. They have asked on page 21 of the court's docket for Mr. Rugani to
Good
be
morning,
called.
Judge.
Rugani? Yes, yes.
Page 24, Mr. Sonny Rogani.
Rugani, okay. All right, these,
Those are the top, so you can get started. If you want to do to the full.
all right, okay.
He's pretty close to the docket, Judge.
We have it. Mr. Rogani, you're before the court this morning for one count of burglary, dwelling structure or conveyance, and count two is grand theft. And the court does find probable cause. And I'll hear from the parties.
The state would be seeking a no bond hold upon the finding of proof evident or presumption great for first appearance purposes only, relying both on the probable cause affidavit, Your Honor, and additionally, the incident investigation report from the Coral Springs Police Department. I would be relying upon not only admissions made by the defendant, but also admissions he made to witnesses, Your Honor. Also, the fact he was found in possession of the firearm stolen from the vehicle as a result of the burglary. One moment, Your Honor. Additionally, Your Honor, if the court does find proof evident or presumption great, I would be requesting that the court not exercise discretion in setting a bond, noting that the defendant is currently on juvenile probation for burglary of a conveyance.
Okay?
And, Judge, we would object to the court making a finding of proof evident or presumption great at this stage of the proceedings. And I understand what Mr. Linder is saying. Despite that, the state hasn't provided any testimony to this court. They've called no witnesses. They've introduced no evidence. And Mr. Rugani is, 18?
17.
17. To hold him no bond at this point, Judge, I think would be somewhat draconian. I'd ask the court to exercise its discretion. First of all, I would object to the court making a finding of proof evident presumption great at this stage, considering that that's the highest presumption of guilt that we have in this country. And to hold Mr. Rugani on a no bond hold is the most severe type of pretrial detention that there is. Especially in light of his age, Judge, I would ask the court not to make a finding of proof evident presumption great. And if over our objection you do make that finding, I would ask you to set a bond for Mr. Rugani and exercise your discretion to do exactly that.
Your Honor, and I apologize, I didn't see this before. Literally 1 week before this incident allegedly occurred June 1st. On May 24th, he had offenses of 2 separate burglaries of conveyances and another grand theft of a firearm. I've got great concern for the safety of the community that twice within a week there are allegations that Mr. Rugani is stealing firearms and the potential for stolen firearms being out on the street. and also I have concerns regarding the statements he made specifically about firearms.
And again, I appreciate what Mr. Linder is saying. Nevertheless, I do believe that Mr. Rugani should have the opportunity to bond out. And maybe Mr. Romero has some more information about Mr. Rugani that he can share with us.
I do, Judge. I know he lives with his parents. He's in 11th grade. He's going to be starting his senior year this upcoming fall. He goes to Coral Springs High School. His GPA, from what he advised me, is not the highest. It's 2.4. He says he could hope it could be higher so he can go to college. Judge, he was already in custody now, I believe, at the Juvenile Detention Center for 21 days. He was direct file. But he lives with his mom and dad. His mom does work. She works in human resources, and I think his father works at a local bank. Judge, as my colleague did say, he's 17, Judge. We would just want the court to have an opportunity to exercise its discretion, so he could potentially, his family could bond him out.
All right. Based on the incident report and the probable cause affidavit that I've reviewed, I do find probable cause. The information before the court this morning, Mr. Rogani is on probation on it'll be juvenile probation, but on this matter, while defense has indicated that he's 17, he has been direct filed on this case. Also with two pending burglaries from May 24th of this year. Now he's before the court on another burglary of a conveyance armed and grand theft of a firearm. This court will also note that in the police narrative, it was the parents who contacted the police and told them that their son was in possession of a stolen firearm. And he made several statements over FaceTime that he had a firearm, that he stole a firearm from a car, showed the bullets were in the magazine. He was on an electronic ankle monitor that they were not able to find. Based on all those that's before the court this morning, I am going to make a further preliminary finding of proof evident presumption great. This is without prejudice for the defendant to have a bond hearing based on State v. Author. Mr. Rogani will be held no bond on that count, and he has a bond of $1,000 on count 2. All right, from our sign-in sheet on page 16, we have David Kretsch. Mr. Rydell. Good morning, it's good to see you. Do we have David, is it correct, this is Kretsch?
Mr. Rydell, bottom center screen.
All right, have you had an opportunity to speak at the state, or?
We spoke, Your Honor, but I think you're going to have to.
Mr. Linder always liked disagreeing, Judge. It's the nature of our relationship.
Okay,
Judge, at this point, I'm going to stand silent on probable cause.
okay. All right, the court finds probable cause as to all counts, and then I'll hear as to bond.
You want, Linder,
I'll
please?
go. Your Honor, and I spoke with Mr. Rydell. I've looked into this. Mr. Kretsch has no criminal history. That being said, based on the allegations in this case, Your Honor, the state would be requesting a $10,000 bond on each count, pretrial release of the GPS monitor, no contact with minors, no possession of any devices with internet access until further order of the court. Nothing further, Judge.
Judge, in this case, just so the court's aware, if you look over my left flank, the court's right flank, his daughter is here, his wife is here, there's other family members here. They lived in South Florida for over 20 years. He's gainfully employed as referenced in the probable cause affidavit, which is more unique that the police chose to, write about not only his cooperation in regarding this situation, but, some of his characteristics and regarding where he's working. I've spoken to the family in terms of possible surety, and while they're probably in the, Mr. Linder's in the $50,000 range, they're more probably in the $15,000 to $20,000 range. What I'm going to ask the court to do is impose a $4,000 bond per count. I do not believe this is a case that, based on the fact that Mr. Kretsch does work in different areas, I'm going to ask the court not. I'm happy with pretrial release. I'm asking not for a GPS, and I'm happy to obviously no contact with minors. I think is a reasonable request. So what the defense is proposing this morning, which I think weighs both safety to the community and flight risk, is I'm going to be asking for $4,000 per count for a total of $20,000 in standard pretrial release with the two conditions Mr. Linder requested, specifically being no contact with minors and no internet access until further order by the court.
Okay. All right. The court finding probable cause, I am going to impose $5,000 on each count. No contact with minors and no internet access. Okay.
Have a nice day.
Oh, I'm sorry, Mr. Mr. Rydell. I know. You ran out really quickly, but there is standard pretrial supervision.
Standard pretrial.
Yes, sir.
That's fine.
Okay.
I'm the answer. I was gonna say goodbye. I thought you were walking to say goodbye.
All right. Jamie Glasgow.
Moscow is in Paul Ryan, Your Honor.
All right, Ms. Glasgow is before the court. Charge 1 is aggravated assault with a deadly weapon. Number 2 is touch or strike battery, domestic, and the court finds probable cause. And I'll hear from the parties.
Yeah, I don't know what Mr. Linder's asking for on this particular case, Judge.
One moment, Judge.
All right,
Your Honor, I see
Yes.
no history. On count 1, we'll be requesting a $4,000 bond. Count 2, a $1,000 bond. No victim contact.
okay.
Judge, I don't know if Ms. Glasgow can make that. I know that she's been a resident of South Florida for all of her life. She has a job as a security guard. She also has a 13-year-old girl. Is that what you told me?
Yes.
I don't think that she has prior contacts with the criminal justice system. And this case, it really seems as though when things play themselves out, as though this might be a stand your ground type of case. The victim, I believe, is the one who actually grabbed the firearm. I would ask the court to consider a pretrial release for Ms. Glasgow. And of course, with the obvious standards of absolutely no contact with the victim, and whatever, no firearms or weapons, whatever other conditions the court thought were appropriate. But from speaking to Ms. Glasgow, this really does sound like a very defensible case.
And Your Honor, obviously, if the court wants to take into consideration ties to the community or lack of a criminal history, I get that. But information, about the facts of the case that she provided Mr. Reedy, really, I don't think is for consideration.
I am going to release Ms. Glasgow to pretrial on level 2. No victim contact until further order of the court.
Keep track of your court dates, Ms. Glasgow. You're going to be released, but you have to report. You're putting it on our GPS, Judge?
Yes.
So they'll put a monitor on your ankle, and you cannot miss court. Do you understand that?
If they have a monitor on my ankle, me and the victim live together, so how does that work?
Well, you
Ma'am,
can't have any contact with her. You're going to find someplace else to
ma'am,
live.
let me tell you, no contact, it means just that. You cannot be living together, there's no phone calls, there is no text messaging, there's no social media, there's no third-party contact. If you need to pick up stuff from the home, I will allow you one time with law enforcement to go and
Okay.
pick up your stuff. Pre-trial will come to the facility to fit you for the ankle monitor, and they'll sign you up there. But I just need you to understand that no contact means no contact.
And we work at one of the same places too, but I won't contact her, but I have to make sure I cover myself.
All right, well, you make sure you do that. 'Cause
Whatever you have to do, just don't have contact
I
with her.
will.
All right, someone signed in on page 9 for Leon Spence. Have you? Leon Spence on page 9,
He's approaching, Judge, he's here at me.
okay. All right, Mr. Spence is before the court, burglary, occupied, conveyance unarmed. Count 2 is robbery by sudden snatching without a firearm or weapon. Count 3 is neglect child without great bodily harm. Count 4, tampering in third-degree felony proceeding. And count 5, touch or strike battery. The court does find probable cause. And I will hear from the parties. While we're waiting, good morning, ma'am. And, are you related to Mr. Spence? I'm sorry? Okay. Is there something that you wish to say to the court today? Okay.
Your Honor, from what I can see, Mr. Spence has no criminal history. That being said, I am concerned about the level of violence in this case, and noting that there was, the officer states that there's camera footage corroborating the victim's account of the events. So, Your Honor, I'm going to be requesting on the burglary of an occupied conveyance, $7,500 bond, $5,000 bond on count 2, $2,500 bond on count 3, $2,500 bond on counts 4 and 5, no victim contact, pretrial release with a GPS monitor.
Judge, what was the bond amount that the state asked for on count 1?
7,500. I'm sorry? Sure, I asked her before if you wanted to.
Something that he was saying at the initial stage about some burglary thing, I'm not sure what he said. Could he repeat it, please?
I was just referring to the first count, which is a burglary.
Thank you, Judge, for giving me that opportunity to speak to Mr. Spence a little further. As you heard, Judge, this is his first contact with the system. He's 30 years old. He has strong ties to the community. First, he appreciates his mother being here for support. Basically, he's self-employed. He has his own mobile car wash. Right now, business is going really well for him. He makes about $400 a week doing that. Now, he lives in Oakland Park. My understanding is he was living with the alleged victim. She moved out. They were paying rent approximately $1,850. Now, he's not in a position to afford that place by himself, so he's going to be forced in a position to basically move out of that residence. Judge, he is going to be depending on his mother and his friends and family to help post his monetary bond. My understanding, Judge, is his mother has limited resources. She works, I believe, at BJ's. He has a friend that's like basically a physical trainer. But he believes that most he's going to be able to come up with, Judge, is about $1,500 bond on count 1, $2,000 bond on count 2, $1,000 bond on count 3, $500 bond on count 4, $1,500 bond on count 5. If my math is correct, that's about $6,500. I know what the state is asking for, I believe, was a total of $20,000, Judge, but financially, he can't afford that. And I'd ask you to take into account his strong ties to the community and his lack of any criminal priors, Judge.
All right, I don't know, the probable cause affidavit that I have says that there were previous restraining orders and domestic violence incidents. Apparently, the restraining order was recently dropped. And these allegations are that Mr. Spence followed the alleged victim to a location where he was not supposed to be at, to pick up the child. And then there was a fight pretty much ensued with this child being in the middle of being grabbed from one car to the other and taken off. So based on those allegations, the court does find that these are serious allegations, and I am going to impose bonds as follows. On count 1, it'll be $5,000. Count 2, $5,000. Counts 3, 4, and 5, it'll be $2,500 on each of those counts. If Mr. Spence is able to post his bond, he will also be on a level 2 GPS pre-trial. No victim contact, which means no phone calls, no text messaging, no social media, no third-party contact. Okay? Yes.
Just for clarification, does the no contact order include Ms. O'Brien, but also the minor child? Since there's a count of child neglect.
Yes.
Okay.
No contact for both. Okay? All right. All right, good luck, ma'am. Mr. Shade, Ami Badir on page 3.
That's North Broward, Your Honor. Come
Okay.
on, come here. Yeah, come on.
All right, Ms. Badir, you're before the court this morning for 3 misdemeanor capious matters. It looks like you did not, on one case, it did not show up for sentencing on May 28th. That's on the prostitution case. And then there's a trespassing matter and also another prostitution. All 3 cases, no show for sentencing. So it looks like this case has already gotten to the place where she's already taken a plea, or so I am just going to leave the bonds in place, and she has to appear before her division judge. I don't know what those previous negotiations were. Okay? All right, Scott Garvin. On page 11, Scott Garvin.
Steve, is that the only one like that? Okay, thanks.
One moment, Judge. We're trying to look at Mr. Garvin.
Scott! approach it, guys.
Okay. All right, Mr. Garvin is before the court for, it's a misdemeanor KPS on a municipal ordinance petty theft. Looks like Mr. Garvin did not show up for arraignment on June 10th. So he does have court tomorrow. What does he wish to do?
There would be a time-served offer from the city of Fort Lauderdale,
All right,
no
Mr.
return.
Mr. Garvin, there's a time-served offer from the city of Fort Lauderdale on this charge. Do you wish to accept that?
Yes.
All right, sir, then please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
You can put your hand down. Mr. Garvin, do you understand everything that's going on here today?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
And sir, you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes.
Have you ever been treated for mental or emotional illness?
No.
And sir, do you understand that if you are not a U.S. citizen, that by taking a plea today it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter, Mr. Garvin? Guilty or no contest?
Guilty.
All right, I accept your guilty plea. I find that it's freely and voluntarily given. Your sentence is adjudication and time served. Good luck, sir. On page 11, Robert Turner.
That's North Broward, Your Honor.
Thank you.
Just go ahead and stand right here on the X.
All right, Mr. Turner, you're before the court because there was a KPS issued for 2 charges. You did not show up for your arraignment as well. This was issued on June 10th. Mr. Turner, what do you wish to do with your case today?
City of Fort Lauderdale's perspective,
Okay,
Judge, from the city of Fort Lauderdale's perspective, they'd like him to go to the division tomorrow. They're not prepared to do the time-served plea. This is
okay.
ongoing is what they're telling me.
There are numerous, okay. All right, so Mr. Turner, you'll go before your division judge tomorrow, who issued the KPS, because at this time, the city's not, making an offer to resolve your case, okay? So you'll see the judge tomorrow who issued the KPS. All right? Jerry Jones,
And I'm not gonna be able to leave?
not today, but
No,
maybe
sir.
tomorrow. Okay? Jerry Joseph on page 12.
He bonded, Your Honor.
All right, thank you. And how about Joseph Emmanuel on page 19?
That's North Broward again, Your Honor.
Okay.
No, stand here on the X. I just happen to be in your way right now. Just give me a second. There you go.
Then that's what we the state case. Emmanuel, page 19.
All right, Mr. Emmanuel is before the court, for charge 1 is criminal mischief, and count 2 is a misdemeanor KPS on a municipal ordinance violation. The state does, the court does find probable cause. Does the state, have an offer on the,
Well, it's a
well,
felony.
no, it's a felony. It's a felony criminal mischief, so the court finds probable cause, and your bond on count 1 is $500, and then your bond on count 2 is $50, sir. Good luck.
Yes, ma'am.
Just ask for no return to this business, Your Honor.
You're able to post your bond, sir. What is the location?
3100 Northeast 9th Street in Fort Lauderdale.
All right, you're not allowed to return to that location. Do you understand
I
that, sir?
understand that. Yes, ma'am, I understand that.
All right, good luck.
Thank you, Judge.
Demaria Davis.
See the present judge and me, the present?
Miss Davis, you're before the court. Charge number 1 is aggravated assault with a deadly weapon. The court finds probable cause. from the parties as to bond.
Your Honor, I see no criminal history. That being said, I'm requesting a $10,000 bond and no victim contact. Considering the allegations are Ms. Davis used a knife to cut the victim. He had injuries corroborating the allegations. Just noting the description of the knife also, and that the victim provided a tape statement. Nothing further, Judge.
Judge, as you know, Miss Davis, she's not gonna be able to afford the $10,000 bond. The defense was gonna be asking for the court to consider a $3,000 bond. As you heard, she has no prior criminal justice system. She is looking forward to her day in court. Ms. Davis did advise me that she was defending herself. My understanding, Judge, is she is working. She works at a place called Sage Dental, where she's a dental assistant. She's been there about 5 months now, making about $15 an hour. Now, my understanding is right now the alleged victim, her husband, and her are in the beginning stages of getting separated. My understanding is he moved out of the family home in June, and it's basically Miss Davis and her child. Judge, my understanding is the only person that could potentially help bond her out is her godmother. Now, she doesn't know her godmother's financial situation, but she is hoping if the court were to set a $3,000 bond, that she could afford to help post her bond using the services of a bondsman.
Well, Mr. Romero, I believe that Ms. Davis told you that the alleged victim has moved out, but the probable cause affidavit says they live on and off together.
They were living together. They're going through a separation. He moved out, but he still has belongings at her residence. And from what she advised me, sometimes randomly he'll just show up.
All right, the court finding probable cause, I will impose a $3,000 bond, no victim contact. So you're going to, no victim contact. It means no phone calls, no text messages, no social media, no third-party contact. You're gonna have to figure that out. Do you understand that, ma'am?
Yes.
Okay. Jornasia Jones.
She's here present, Judge. She declined the service of public defender.
All right, Ms. Jones, you're before the court for a traffic KPS. It's a charge of operating without a valid license, and the court finds probable cause. Ms. Jones, what do you want to do today?
Bueno.
I'm sorry?
Bueno.
Okay, well, your bond is $1,000, okay? That's a bond that was
Okay.
set, on the KPS. All right?
Okay.
All right, good luck. Iris Espada.
Your Honor, she's North Broward. She's gonna need a Spanish interpreter. Mr. Reddy's already aware of it.
All right.
Yeah, we
thank
have
you.
one on the way, Judge.
Okay, thanks. Lourdes Rodriguez. Her bond has been posted, okay? Is Ms. Rodriguez still in custody? No? Okay. Ms. Rodriguez, bonded. Renee Alicia Day,
North Broward, Your Honor.
thank you. All right, Ms. Day is before the court this morning for charge 1 is burglary, unoccupied dwelling unarmed. 2 is possession of burglary tools with intent to use. 3, committing grand theft with property damage. 4, burglary, unoccupied dwelling unarmed. 5, possession of burglary tools with intent to use. 6, committing grand theft with property damage. 7, burglary, unoccupied dwelling unarmed. 8, grand theft. 9, false owner info for pawn items. 10, dealing in stolen property. 11, burglary, unoccupied dwelling unarmed. 12, grand theft, and 13 is a misdemeanor capias. And the court finds probable cause as to all those counts. And does anyone wish to be heard as to the bonds?
Your Honor, I'm going to be requesting a $15,000 bond on the 3 burglary dwellings. Ms. Day is currently out on $7,000 worth of bond for 2 counts of dealing in stolen property. Those charges, the allegations are, she went onto people's property. There was, one moment. In one instance, storm shutters were taken from a home. In another instance, copper decorative items were taken from another person's yard for the purposes of scrapping. And I believe there's references to that in this case. This is ongoing criminal behavior. It fits the same MO, Your Honor. I believe she's also out on a theft. I have no reason to believe that without the proper bond and release conditions, that Ms. Day will not continue to take people's property for the purposes of scrapping metal. I'd also be requesting a GPS monitor on this case.
Okay.
I spoke with Miss Day's mother. She does have a 7-month-old child who is currently with the father. But Miss Day's mother is not going to be posting any bonds for her, Judge. So I would ask for a reasonable bond.
All right? I'm sorry.
No, go ahead.
I apologize. She also has a lengthy criminal history out of the state of North Carolina. 2016, larceny. 2016, with the failure to appear, larceny, failure to appear in a felony, felony possession of controlled substance, fleeing and eluding arrest. 2012, possession of controlled substances with intent to distribute. A DWI in 2012. Possession to distribute immediate precursor chemical substances. That was in 2008. Same offense in 07. And
You done yet?
I don't know. I'm trying to see if there's more. There's a lot here.
Okay, keep going.
That's it.
Yeah, the pending theft is still from 2017. She already failed to appear in court on that case at least once.
Yeah, you know, speaking to her mom, I just know what to tell you, Judge. She's not going to be able to post any kind of a monetary bond, and the only thing I could ask for is pretrial release because she has no money. Her mom is not going to bond her out. And you can tell by her reaction, I think, as you look at her right now, that maybe all of this is starting to come home to her, I hope, anyway. I know it's all shutters, and as, Miss Day and I discussed, people's shutters don't necessarily belong to you. It seems like the 7-month-old is in a stable environment, which was, quite frankly, my main concern. I would just ask you to set a reasonable bond for her, and maybe she and her mom can work something out over the phone to get her out.
Your Honor, this has been consistent, ongoing criminal behavior for the past 12 years. It's convenient to say now today, on June 26, 2019, when she stands before the court on these serious charges while already out on a felony, that now she's learned her lesson.
Well, now she has a 7-month-old.
She had a child when she was arrested for dealing in stolen property.
All right, what I have before me this morning is 4 different occasions of the same type of burglary and then dealing in stolen property. And so, based on what's before me this morning and the prior criminal history, on count 1, I am going to impose a $7,500 bond. It'll be the same on count 4, count 7, and count 11, and then the other standard bonds will remain in place. So 7,500 on 1, 4, 7, and 11, and the other standard bonds will remain in place. And should Ms. Day post her bond, she will also be on a level 2 GPS anchor monitor.
I'll let your mom know what your bonds are.
And Your Honor, no return, no contact?
Right, and don't go back to these places.
Thank you,
That's
Judge.
basically what that means. Alexandra Blakely,
North Broward, Your Honor.
okay?
Blakely, come on in.
Your Honor, you don't have the affidavit, I imagine.
On which one?
This case, Miss Blakely, or do you?
Did you,
I just had the warrant. I didn't have the affidavit. I've been trying to reach out to the detective to get a copy of the affidavit. No, I couldn't. I don't have it.
no, that's right, I just have the
So
warrant
I'm
and
gonna
I don't
ask that we
have the.
put it on, if we reset the matter.
Okay, to reset till tomorrow?
If you
Or
want to put it
this
for the afternoon,
afternoon.
I can try. I mean,
All right, we'll reset Ms. Blakely for this afternoon, okay?
Is that okay,
She's
Miss
not on the
Blakely?
docket.
Well,
If she's not on the docket, I'll still bring her down, just in
Thank you,
case.
thank you.
Sometimes
And
that
I'm gonna
happens.
call Charlie
All right.
between now and then, okay?
All right,
Hey,
Amy Hernandez,
she ain't on the docket, we have to bring her back down. Yeah.
where do we have Amy Hernandez? Is that Maine?
Judge, I've been informed she bonded.
All right, thank you. Tiffany Hackett? I did. Tiffany Hackett,
North Broward, Your Honor.
okay. Ms. Hackett is before the court. These are additional charges. 7 is larceny, $300 less than $10,000 from a person 65 or older. And then count 8 is a felony violation of probation with a no bond hold.
Yes, ma'am.
Oh, I don't know if she's done. I wasn't paying attention.
No, I'm not
I
done.
just ask you to leave the bonds in place, Judge.
Okay. I'm just looking, because it's the same, like, information from before. So, you do have a bond of $1,000 on 7, and on count 8, there's a no bond hold, but you'll be before your division judge tomorrow at 8:30. Okay?
Okay,
All right.
thank you.
You're welcome. Robinson Knight,
thanks.
Case here present, Judge Amanda.
all right, Mr. Knight is before the court on a felony battery, domestic in nature. The court finds probable cause. I'll hear from the parties.
One moment, Judge. Your Honor, I'm going to be requesting a $15,000 bond, no victim contact, pretrial release with a GPS monitor. This is based not only on the facts in this case, but Mr. Knight's lengthy history of violence against this same victim. 2018, he was convicted of battery and violation of a pretrial release condition, that being the no victim contact order against the same alleged victim. He was sentenced to 364 days in county jail. 2018, felony battery due to priors to the violation of probation, 364 days, that was against the same alleged victim. 2017, felony battery, domestic violence by strangulation, aggravated assault with a deadly weapon, and battery against the same alleged victim. Those charges were dropped. 2013, felony battery due to priors with a violation of probation. The alleged victim in this case was one of the victims in that case. He also has a 2005 battery against the same alleged victim. Nothing further.
Judge, first, this is a not in custody KPS. When was the date of the alleged incident on this case?
April 26.
Thank you, Judge. And speaking with Mr. Knight, we're going to be requesting that court consider setting a $2,000 bond on his behalf. Now, he's been here his whole entire life. He's 39. He just got a job. He's been there for about 4 months, working for like an assembly company, where he's getting paid approximately $11 an hour. My understanding, him and the alleged victim do not live together. He lives with his mother. He's been living with his mother in Fort Lauderdale for about 6 months now. He pays approximately $140 a week to help his mom out with as far as the bills and things of that nature. His mother is the person that he's going to turn to help post his monetary bond. She's employed. She basically cleans houses for a living. He also pays in his current, from what he advised me right now, he pays child support in the amount of $101 per week. Judge, there's no way from what he said he's going to be able to afford the $15,000 which the state has suggested, and that is why I'm asking for a $2,000 bond on Mr. Knight's behalf, Judge.
Well, the allegations here are that Mr. Knight appeared at Ms. Robinson's home. When she opened the door, he punched her and left the scene. And the information presented to the court today is that there's a last year conviction with the same victim, and that there have been prior domestic violence matters. And with taking all of that into consideration, at this time, the court is going to impose a $30,000 bond. If Mr. Knight posts his bond, he'll be on a level 2 anchor monitor. No victim contact until further order of the court. Okay. Deron Tiggett.
Mr. Tiggett is approaching. Mr. Tiggett, come on up, please.
Mr. Tiggett is before the court. Charge 1 is possession of cannabis over 20 grams. And number 2 is a misdemeanor KPS. Mr. Tiggett did not show for his arraignment on a battery charge on March 7th of 2019. The court finds probable cause. And does anyone wish to be heard?
Judge, nothing as far as right now the bond, just except on count 2. Who is the alleged victim and when was the date of incident on the case?
I don't have that information because it's a KPS for a failure to appear.
And, Your Honor, this isn't from an issue summons. Frankly, it's from a failure to appear at arraignment, so I don't know that that's necessarily relevant to this hearing.
Okay. All right, so here's a,
So no.
And he can consult with his attorneys at the
all
appropriate
right,
time.
so the standard bonds that are in place will remain. Tyrell Fairclough.
Thanks, Mr. Leonard, for that help.
Your Honor, you're very welcome, Hector. Professional as always.
All right, Mr. Fairclough is before the court for a felony KPS on a battery charge.
Your Honor, it's a change of charge, but it's still, it was I'm looking at the original findings that you had, Your Honor, and it said battery caused bodily harm, domestic violence, and it's been filed as a battery. Your Honor set the bond originally at $2,000. He's got $60,000 worth of bonds on other charges, and
Is this one of those, well, is it a true change of charge, or is it just that,
it's a technicality.
okay. All right, how much was his bond before? 2,000?
2,000.
All right, so we'll leave that in place. All right. Omar Barnes is removed from the docket, okay. Romero Pierre,
Medical.
all right, it's a medical reset for Mr. Pierre. Marcus Williams,
Mr. Williams coming up?
all right, Mr. Williams is before the court. Charge 1 is driving while license suspended. 2 is unlawful speed that's not for magistrate, it's a traffic infraction. And then count 3 is an out-of-county misdemeanor hold. The hold is out of Bradford County for failure to pay child support. All right, the court finds probable cause.
Judge, and speaking of Mr. Williams, I did advise there's nothing the court can do in reference to count 3, but in reference to counts 1 and 2, Judge, he wishes to resolve that matter. And Judge, we'd ask if the court were inclined to resolve this matter, if and through his plea, would the court consider dismissing the traffic infraction of count 2?
All right, does the state have an offer for?
One moment, Judge. I'll make an offer, Your Honor. The issue, he needs to be advised. From what I'm showing here, and Michelle, if you can confirm, are you showing he's registered? I'm showing he's registered, Your Honor, so there could also be other ramifications.
I didn't know that, Judge. Let me have one brief moment.
It's okay. I confirmed it.
Judge, in lieu of that information, we're not requesting anything at this time, just leave everything as is.
Okay. Eric Kozikian,
He's approaching, Judge.
all right, sir, you're before the court this morning. Charge 1 is obstruction by disguise, and 2 is trespassing on occupied structure. The court finds probable cause.
Judge, Mr. Kurzian, how do you pronounce? Kazikian. Mr. Kazikian is actually looking forward to having his day in court. Is, my understanding, Judge, is was trespassed at the pool. That's where he actually lives in that complex. It's called Wynwood Lakes Apartments, where he's been residing at for about 3.5 years. He lives there with his parents. He's been here his whole entire life. He does not know why the police went and basically stopped them or inquired of him when all he was doing is basically enjoying the amenities of his apartment complex. So, Judge, at this time, we're going to be asking for the court to consider releasing Mr. Kuziyan on ROR or in the alternative on pretrial release.
Are there any priors?
All right, I gotta go. All right, bye. Yes, Your Honor. Possession of PVP 2015, trespass 2015, disorderly conduct 2015.
All right, so, the police report here says that he was trespassed from the location by the property manager and that he refused to leave the area. That's what the report says. Nonetheless, I will release Mr. Kozikian to pretrial supervision, okay? Sir, you need to make sure that you report to the pretrial office within 24 hours of your release. Failure to report to the pretrial office, a warrant will be issued for your arrest. Do you understand that, sir?
Yes, I do. Can I say one thing?
Not about the facts, no.
All right.
Okay. Joseph Mongilo,
Bonded, Judge?
okay. Eric Mills,
Bonded?
okay. Do we have Cedric Greer today?
Your Honor, he's still showing on loan when I looked him up this morning.
Okay, thank you. And Michael McLeod,
Mr. McLeod declined our invitation to appear this morning, Your Honor.
Mr. Reedy, did you speak with him?
No, I did not speak with him, but I did speak with Deputy Sanchez at Conte,
Okay.
who informed me that Mr. McLeod would rather catch a little bit more shut-eye than attend court.
All right, so these are ad charges.
And I don't know if Mr. Reedy has an objection. He has multiple other bonds on, as you can see, multiple other charges, both in Broward and Palm Beach. I was gonna be requesting a $1,000 bond on 35. It's a file
Right.
that charge.
All right, so.
You know, I didn't get any input from him, so fine.
All right, so 35 is burglary, unoccupied conveyance, and 36 and 37 are petty theft charges. And the court finds probable cause, and it will impose a $1,000 bond on 35, and there's a $100 bond on 36 and 37.
Fair enough.
All right, Kenneth Jennings,
Mr. Jennings, Judge is approaching. He's here at Maine.
all right, Mr. Jennings is before the court on aggravated battery with a deadly weapon. The court finds probable cause.
Your Honor, state would be requesting a $15,000 bond, no victim contact, based on the level of violence alleged in this case. And also noting 2011, Mr. Jennings was convicted of 2 counts of aggravated assault with a firearm.
Okay,
Judge, as you heard, I believe last time he had contact with the assistant was about 8 years ago. He's 49 years old, been living here in South Florida now for 12 years. He served our country in the United States Army from 1986 through 1999, Judge. He does get disability. He's been residing at those premises with that roommate at Oakland Park now. That's his roommate, Judge. He's been actually living at that place for about 11 years now. I did inform him that the court's going to order a no contact order. He will be abiding by that court order. Judge, we're going to be asking for a photo order so we can photograph the injuries that he sustained. But Judge, we're going to be asking on his behalf a $5,000 bond for Mr. Jennings.
okay. All right, I will impose a $7,500 bond, no victim contact, and no possession of any weapons or firearms, okay? Devin Chandler,
Your Honor?
Chandler's here at Maine, Judge, approaching.
yes.
I'll wait till he gets up there. Your Honor, I'm going to ask that this matter be reset for 2 o'clock this afternoon. Well, for the afternoon, but Detective Carlo Fargnoli, who investigated this matter, can be present in court to present testimony at that time.
Okay. We'll reset till the PM on Mr. Chandler. All right, Jeremiah Henry.
And, Your Honor, I believe this is one of the cases I provided the court probable cause affidavit on.
All right, Mr. Henry is before the court. Charge number 1 is burglary on occupied dwelling unarmed. 2 is grand theft, and 3 is a misdemeanor capias. And the court finds probable cause. And I'll hear from the parties as to bond.
One moment, Judge. Your Honor, I'm going to be requesting a $10,000 bond. I'm sorry, $15,000 bond on count 1. I would note it does not appear, I don't know if Mr. Henry has any ties to the community. He was extradited here from Connecticut, and one moment, Your Honor. It would appear he has a history out of the state of Connecticut. Showing sentence assault, 2015, sentenced to a year in jail, breach of the peace. He's violated probation, drug possession, failure to appear, unlawful threats, breach of the peace. Nothing further, Judge.
Judge, speaking to Mr. Henry, the state is correct. He is hiding in Connecticut, specifically in Hartford. Him and his mother rent an apartment. He was working before he was incarcerated in Connecticut. He's been in custody now for about 6 months. He finally arrived here about 4 days ago, so he hasn't been working right now. Whatever job he had or whatever savings he had is basically long gone at this time. Judge, what I'm going to be asking for is a $2,000 bond. As you can see, this is basically a 2015 offense. So I'm asking for a $2,000 bond on Mr. Henry's behalf, Judge.
Well, what is the status of the cases? He was extradited here. What is the status from Connecticut on those cases?
He has nothing open in Connecticut, Judge.
He was just arrested on the extradition
He
warrant.
was arrested on this?
Yes.
Okay. All right, so on count 1, I'll impose a $5,000 bond. Count 2, 1,000, and then there's that capias with a $250 bond. Okay? Leon Hill?
Mr. Hill, come on up, please. He's approaching, Judge.
Okay. All right, Mr. Hill is before the court on an aggravated assault with a deadly weapon without intent to kill. And the court finds probable cause.
Your Honor, I'm requesting a $5,000 bond, no victim contact. He is misdemeanor priors. I don't see any violence, but I am concerned that he's one moment. Allegedly threatening the victim with a knife, threatening to kill the victim, and noting that there was a witness to the incident that provided a sworn statement.
Okay.
Judge, in speaking with your Hill, as you heard, basically this is his first felony offense. I believe he had prior traffic or cannabis maybe like 9 years ago or something like that. But he is a registered voter in our community. He is working, he was working, I believe this incident allegedly occurred at his place of employment at Denny's, where he's been employed there for well over a year. He was actually the store manager, so he's quite confident that now he's lost his job. He lives with his mother. They rent an apartment in Fort Lauderdale. My understanding is his mother is a crossing guard, so right now she's not working. He's anxious to be out there to help his mom out because she depends on him for the rent. But Judge, right now, from what he's advised me, since she's not working, she's not in a financial position to post a monetary bond. He's asking, because he doesn't have the ability to bond out right now, if the court would consider releasing him on supervision with pretrial release, Judge.
All right, I will grant release to pretrial supervision with a income monitor. Level 2. And that includes no victim contact and no possession of any weapons or firearms. Christopher Pace.
Mr. Pace is approaching, Judge. Come on up, Mr. Pace. Please here remain.
All right, Mr. Pace is before the court. Charge 1 is possession of controlled substance without a prescription, and number 2 is possession of drug paraphernalia. The court does find probable cause.
Judge, I don't think that at this time.
All right. So Mr. Pace has a total of $1,000 bond. Daniel Goodling.
Mr. Goodman, come on up, please.
All right, Mr. Goodling.
Your Honor?
Yes.
I'm sorry, I have...
Oh, I was gonna say, do I have a bigger paragraph? Okay. All right, Mr. Goodling is before the court on charge 1, distribution or delivery of methamphetamines. Count 2, possession of methamphetamine. Count 3, possession of cocaine. 4, 5, and 6 are felony capious matters that are no bond holds and not for magistrate. The court does find probable cause. Does anyone?
Considering he has no bond hold, nothing to add from the defense.
All right, so the standard bonds will remain in place. He does have court tomorrow before his division judge. Stephen Lucas.
Come on up, sir. Here's Mr. Lucas, Judge.
All right, Mr. Lucas is before the court for grand theft, and then 2 is no bond hold on a violation of pretrial. The court finds probable cause. And Mr. Lucas' bond on count 1 is $1,000. Tyrone J.
Mr. J is approaching, Judge.
Sorry, no, it's...
He's coming, Judge.
Okay.
Same meeting that Maria's on, or-
Mr. J. All right. Mr. J is before the court on one count of burglary, unoccupied dwelling unarmed, and count 2 is touch or strike battery. The court finds probable cause. So I'll hear from the parties as to bond. Mr. Romero, you can go ahead.
Judge, Mr. J informed me, that he's not in a financial position to post any sort of bond. Now, he's 58 years old, he's been here his whole entire life. He is working, he's been, working at the same company now, it's called Tire Plus, for 6 years. He's making approximately $9 an hour. He lives locally here in Fort Lauderdale, he lives with his mother. His mother is retired, collecting Social Security. Now, he did advise me he has priors, but he believes it's about over 5 years old. Judge, he was hurt as a result of this incident. My understanding is he was hospitalized and now he's in the medical unit. We're gonna be asking for a photo order so we can photograph the injuries that Mr. J sustained. And also, because he's not in a financial position to post any sort of bond, we're asking the court to consider level 2 pretrial for Mr. J.
All right, state.
One moment, Your Honor. Your Honor, I'm going to be requesting a $10,000 bond, no victim contact. Mr. J had a loiter, and this is just as far as Broward. He had a loitering and prowling about 2 years ago. In that instance, he was walking back and forth and up to parked vehicles in the parking lot. The officer had a concern that a burglary of vehicles was imminent. 2013 theft. 2008 burglary of a dwelling. He violated probation. He was sentenced to 57 months state prison as a habitual offender. Let's see. Multiple drug priors. And I would note in this instance, well, first I would note he's got aliases. And when he was confronted by the, I believe it was the victim's neighbor, he made threats against the people. He threatened that he would come back and rob them. There's also an allegation of a battery.
All right, at this time, I'm gonna impose a $5,000 bond on count 1, and no return to that location, okay? All right, James Carr? Mr. Carr bonded,
Bond, Judge.
all right? And then Rakeem James? Rakeem James
May I find you bonded? Judge?
bonded, okay?
Mr. McCall?
Yes, Quincy McCall?
Judge, he's approaching and we're gonna be waiting for him reading the charges.
Okay,
Oh, Your Honor, I'm sorry. I'm asking that this be reset for the afternoon. The detective in the case will be present, the ASA handling it, and also we will have, I don't believe Your Honor has an affidavit for this case either. We'll have that for Your Honor this afternoon.
I have the probable cause affidavit, and I have the warrant to arrest.
Judge,
But-
is it possible we could go ahead and put the mark number on there, that number that's on the findings,
Warrant where?
where the, I think it said 33, something like that.
Yeah,
Yeah, it should be 190379 AF10.
on all of them?
You can just write one.
What is it again?
It's
19?
on,
190379 AF10.
and that's on 2 through 6, Your Honor.
2 through
The PC affidavit is for count one.
Okay. All right, but we'll reset this for the afternoon,
Please.
okay? Yes. Keandre Lindo,
Mr. Lindo is here present, Judge. He's coming up and he declined the service as public defender.
all right, Mr. Lindo, you're before the court. Charge 1 is resisting officer without violence. And then 2 and 3 are violation of felony pretrial. Those are no bond holds and not for magistrate. So the court finds probable cause and you have a $100 bond on count 1, okay? Arthur, I'm sorry? Arthur Demine, is Mr. Demine still on medical loan or loan? Yes, okay, Mr. Demine. Jesse Ritchie,
Mr. Ritchie is here present, Judge May.
all right, Mr. Ritchie is before the court. Charges 1, 2, 3, and 4 are distributing or delivering cocaine. 5 is trafficking in cocaine, 20 grams or less than 200 grams. 6 is possession with intent to sell, manufacture, deliver cocaine. And 7 is possession of heroin. Oh, this one. That took me a little while to read.
Yeah, I called
It's okay.
the detective, Your Honor.
The court finds probable cause. And does the parties wish to be heard, Esteban?
Judge, I believe if my math is correct, is close to a $28,500 bond. Mr. Ritchie said that's outside the possibility of him or his family. We're requesting an $11,000 bond. We're requesting a $1,000 bond on counts 1 through 4. We're requesting a $5,000 bond on counts 5 and a $1,000 bond on counts 6 and 7. That would be $11,000. My understanding is he's 27 years old. He's been here his whole entire life. He's working. He works for a company called Tropical Vacations as a sales representative, where he's making about $10 an hour. Now, he lives here locally in Coral Springs with his aunt. He's been residing there for the past 10 years. His rent is about I believe the total rent is about $800 a month, which he shares that expense with his aunt. And his aunt cleans houses for a living. So, Judge, using the services of bondsman, he believes if the court were inclined to set a total bond of $11,000, that's something that maybe his family can come up with.
Your Honor, I'm going to be requesting a $50,000 bond on count 5 with pretrial release GPS monitor. Mr. Ritchie is currently out on 2 separate felony cases, one for possession of cocaine, the other for possession of substituted cathinones, carrying concealed firearm, misdemeanor possession of cannabis, possession of drug paraphernalia, and DWLS.
When was that when was the date of that arrest?
They're both 2018 cases, Judge.
Okay. All right, so at this time, the court finds probable cause. How much bond did he post in the other case?
All right, one moment, Judge. I know the cocaine case he ended up being ROR'd on. He posted bonds on the cathinones case. He ended up getting picked up on a no bond capias. And he then ended up he was ROR'd on everything eventually by Judge Tobin Singer.
All right, so I'm going to leave all the standard bonds in place, okay? Paul King,
Mr. King is approaching, Judge. He's here at me.
all right, Mr. King is before the court. Charge 1, robbery with a firearm. Count 2, aggravated battery with a deadly weapon. Count 3, burglary with assault or battery. Count 4, resisting officer with violence. And count 5 is violation of felony probation. And the court finds probable cause. And does anyone wish to be heard?
Your Honor, on counts 1 and 3, I would be seeking a no bond hold upon a finding of proof evident or presumption great for first appearance
State is asking
purposes.
no bond for these two.
On count 2, I'd be requesting a $50,000 bond. On count 4, a $5,000 bond. As you can see, Your Honor, Mr. King is on probation for attempted murder in the first degree. He's actually on probation for attempted murder, aggravated battery with a deadly weapon, and possession of a firearm by a convicted felon. He was sentenced to 5 years state prison as a habitual violent offender, to be followed by 5 years of probation. In '07, he was convicted of battery on a prisoner, sentenced to 5 years and a day state prison as a habitual offender. In '06, he was convicted of aggravated assault with a deadly weapon and felon in possession of a firearm, 5 years in a day state prison habitual offender, MPRR offender. And in 2003, he was convicted of carjacking with a firearm or deadly weapon and robbery with a firearm or deadly weapon. He violated probation, was sentenced to 5 years in Florida State Prison.
In light of the fact that Mr. King is currently being held on a no bond hold for the violation of probation on count 5, we would defer any argument regarding proof evident presumption great until such time as Mr. King can appear in front of his division judge.
All right, this time the court finding probable cause. I will make a further preliminary finding of proof evident presumption great. As to counts 1 and 3, Mr. King will be held no bond as well on those counts. On count 2, it'll be a $50,000 bond, and then on count 4, $5,000 bond. And he does have court tomorrow before his division judge.
Judge, we'd be requesting a photo order from Mr. King.
Sure.
Is that photo?
Photographic, yes.
You got it.
All right, Tanarvis Lawhorn.
Mr. Lawhorn is here in Maine. Judge approaching. Come on up, sir.
All right, Mr. Lawhorn is before the court. Charge 1 is false imprisonment. 2, grand theft auto. 3, touch or strike battery. And 4 is a misdemeanor capias. And the court finds probable cause.
Your Honor, I'm going to be requesting bond in the following amounts. $20,000 on count 1. I'm going to be requesting a $5,000 bond on count 3. No victim contact. Pretrial release with a GPS monitor. Your Honor, I would note the allegations in this case. I would also note, as you can see, he has a capias for a battery at a South Satellite. The alleged victim in that case is the same as the alleged victim in this case. Additionally, Your Honor, Mr. Lawhorn has recent criminal history involving violence. 2016, robbery by sudden snatching. In 2018, he was sentenced to just over 20 months state prison as a habitual offender. He was released from state prison January 1st of this year. Additionally, possession of cocaine, 2013, just over 23 and a half months state prison. Another possession of cocaine, 2012, 2011. Dealing in stolen property and false ownership info on a pawn item, 23 and a half months. Burglary of a dwelling and grand theft, 2011, 23 and a half months. Possession of cocaine, unlawful use of false name ID, 2010. Nothing further.
Judge, Mr. Longhorn works. He works
Just give me
for
1
a
second.
construction company, GMA. He just started. They pay him daily. He gets about $100 a day. He lives in Fort Lauderdale with both his grandmother and his aunt. They are both on Social Security. My understanding, he's been here his whole entire life in South Florida. He's 32 years old. We're asking you to take that into consideration, determining reasonable release conditions for Mr. Longhorn.
All right, based on the information that has been presented to this court, prior criminal history, fact that there's a pending,
Judge.
yes,
I'm sorry, one more important piece that I totally forgot. My understanding is when Mr. Longhorn, I believe, law enforcement responded to his house to, basically inform him of the warrant. He wasn't home. His mother went ahead and basically, when Mr. Longhorn, arrived, informed of what happened, that they came regarding an outstanding case. From what he advised me, I believe he went and surrendered himself regarding these offenses. So as evidenced by that, I don't believe he's a flight risk. He's looking forward to having his day in court on this. So Judge, I want to also have the court take that into consideration as well.
I do have that information, that was in the reports that were given to me. I am imposing a $50,000 bond on count one, no victim contact, the other standard bonds will remain in place.
And Your Honor, the only other request I'd make, I didn't realize,
And no weapons or firearms, there's a allegation of a gun,
count 4 is from an issue summons.
yes.
So since it's his first time appearing before a judge, I'd ask if the court would impose no victim contact with Demetra Thomas on count 4 as well.
Is that the same,
Yeah, it
it's
is.
the same, you're right, that's the
Yes.
case that I said, it's the same pending with the victim.
Yes, ma'am.
All right, so no victim contact, and no weapons or firearms, okay? Jose Meza,
Mr. Mesa, come on up, please.
all right, Mr. Meza is before the court, carrying a concealed firearm, possession of cannabis 20 grams or less, tampering, count 3 is tampering with or fabricating physical evidence, and then count 4 is a traffic infraction that's not for magistrate. Right, and the court finds probable cause.
Judge, Mr. Mesa is requesting pretrial. We want to see if the state has an objection to that.
That's fine, Judge.
All right, so Mr. Meza will be released to pretrial supervision, be ROR to pretrial. Okay. Mr. Meza, you need to report to the pretrial office, the information that has been given to you within 24 hours of your release. If you don't report, a warrant will be issued for your arrest. Do you understand that, sir?
Yes, ma'am.
Okay, good luck.
Oh, thank you.
All right, Daryl Knowles,
Keep bonded, Judge.
all right. And then Malik Murphy. Okay. Mr. Murphy is to be reset to the PM. Evan Johnston,
Recall that for just a few moments, Judge. His mom is currently looking us up online,
looking you up online?
looking all of us up online.
Okay.
Because she would like to join in the proceedings.
Okay. Alexander Henderson,
Your Honor,
Paul Reiner.
yes.
I'm going to ask that this be deleted from the docket. I spoke with confinement status and actually spoke with the prosecutor in the case. Mr. Henderson had an Arthur hearing in front of Judge Coleman yesterday.
Yes.
All the charges before the court were addressed with respect to bond and release conditions.
Okay. So we're deleting Mr. Henderson. He's already been addressed. And then Cartala, William Baez
The
Cartala,
downtown judge.
he's in court.
Same with Mr. Mathis.
And Mr. Mathis is in court.
Well, Your Honor,
Yes.
with Mr. Mathis.
Isn't that the same charge?
It's a little different. Well,
Yeah.
Your Honor signed a, Your Honor
I'm just
revoked
giving him a
him or
chance
did
to
a
go
pretrial
online.
I
revocation.
remember,
So I
but,
just asked that it should just be kept at no bond. It's really for his judge to decide if he gets a bond at this moment.
so, okay.
Where else you got to go? It's 10:20 in the morning.
You know what? It does say not for magistrate.
Oh, does it?
It does.
Great.
All right.
I don't know, does the jail need a finding though?
Is this for count two?
For Mathis,
Yes.
yes.
Yes, to reflect that there's no bond?
It,
Yeah.
it doesn't reflect no bond, but it says not for magistrate. So, do we need to write no bond in there so it doesn't have to come back? Or is it okay?
Yeah, no.
Nope. We're almost to the end. Yerandi Shaviano Machado.
Conti, Your Honor, he's in courtroom 4780.
It must be that day. Thank
Well,
you.
he's being arraigned today.
All right. And then Darius Rice.
He's here in Maine?
All right, and so Mr. Rice is before the court for of violation of pretrial on a felony matter. And, is this on a warrant? It says no bond hold
Yeah, I don't know why
for
this
magistrate,
is.
but then it says not for
I
magistrate.
think this is the same situation. There must have been
It was
a change of charge.
He was violated, judge, on a pretrial, but then the charge was changed.
Oh,
Back to the COC, part of pretrial one.
so it's back to no bond, or do we need to write that in? Okay. All right. All right, and then, before we make a phone call, Kevin Myrick, is there additional information, Mr. Linder? Oh, you did, did
Did I
you
provide? I think I did.
Yes, he left his number, but I don't know if he read the probable cause affidavit.
I don't, I
You read it
spoke,
to
I
him?
read it to him over the phone.
Okay. All right, is Mr. Myrick there?
Yes. Come on up, Mr. Meyer. You have Mr. Douglas, right? Yes. Okay.
All right.
When you wanna talk, I'll press it.
This is Rick.
All right, Mr. Douglas, this is Judge Powell. We're calling from First Appearance Court.
Thank you, Your Honor.
You're on speakerphone in open court, and I have Mr. Myrick before me. Have you had an opportunity to review the additional?
I have, Your Honor.
Okay.
It's either one of two things happen, Your Honor. And the most important, you have possession of a firearm by a convicted felon, and the officer leaves out the most important part, that the alleged victim said that he had the firearm in his hand immediately prior to her leaving. So I asked the court, yes, the document shows probable cause. I asked you to look at the credibility of it, though. Either the officer was incompetent and completely forgot the most important part, or they went back to the alleged victim, and now the alleged victim has changed or enhanced her story to say not only that he threatened to kill me if I called the cops, but he also had a firearm in his hand when he did it.
Oh.
And
Go
and with
ahead.
that in mind, I'd ask the court to set a bond for $2,500, and then on the grand theft of a firearm, there's still I still argue to the court that is lacking probable cause. basically with grand theft of a firearm.
I'm not arguing that there's probable cause for grand theft
All right,
firearm.
I was gonna find no,
Good,
no,
okay.
all right, so I'm finding no PC for the grand theft of the firearm, because there's no information there as to that.
Your
And,
Honor, I would note there is another explanation that doesn't necessarily involve the deputy being incompetent, but I'm sure she appreciates being referred to that way, for
I
no
said
base.
one of
Wait,
two
excuse
things. I
me,
mean,
excuse me, Mr. Douglas, I didn't interrupt you.
I'm sorry.
With no basis. And that is, Your Honor, as you can see, another deputy wrote the PC and handled the investigation for the battery. It's mentioned in the supplement, that's who was told about the statement. And Deputy Nunez wrote the PC for the possession of firearm by convicted felon. She went back, she contacted the deputies again, she got that information, she included it. That's the whole reason for perfection, is sometimes if the court feels there's not enough specific evidence, the state gets time. But there's a sworn affidavit here. This officer swore, under the penalty of perjury, that this is the evidence that has been presented to her.
all right, so finding probable cause for the possession of weapon or ammo by a convicted felon. I will impose a $2,500 bond, and I believe yesterday he had a $1,000 bond on the other charge, so.
For the domestic. And
Okay.
then, Your Honor,
Yes.
he also right now currently has a $1,000 bond that's administrative on the grand theft. I'd ask that the order say that it's reduced to ROR.
Well, I wrote in no probable cause found on count one, so
It's
that takes
automatic,
care of
yeah.
it. It's automatic, okay?
Okay, so in other words, the jail knows to withdraw the $1,000 bond on that.
They do. They're looking, they're giving me rolly eyes, so they do.
It's not you,
And
Judge.
thank you. And I'm not being trying to be disrespectful.
No, 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 no.
On this particular PC, you know.
No, I hear you. I hear you.
Thank you.
All right,
Thank you.
Mr. Douglas, take care.
Okay, bye.
All right, good luck, Mr. Myrick. All right, no Spanish interpreter, that's unusual. Is it a busy day? They forgot about us.
Yeah, I did call earlier and they were like, oh, that's right, we forgot.
Are they coming?
There's one on their way. There's a Spanish interpreter.
Somebody's on their way? Okay,
You have, Mr. Johnson. And I'm on the phone with his mother.
okay, so Mr. Johnson is before the court. Count one is robbery with a firearm. Count two is trespassing. And the court finds probable cause.
Your Honor, oh, I'm sorry. Count one should be an attempt.
Yeah, it should be.
I spoke with the deputy and confirmed that.
Okay. So we'll find for attempt.
Um,
All right.
one moment. Okay. I'm going to be requesting a $20,000 bond. No victim contact, pretrial release of the GPS monitor. Mr. Johnson is currently out on bond in Broward right now for possession of fentanyl, possession of cannabis, drug paraphernalia. That's from, his arrest was January of this year. I'm also showing lengthy drug history out of the state of Pennsylvania. Showing an at-large address. I have concerns that this offense could have been drug motivated, and that gives me pause for potential future acts of violence in the community.
Okay.
Judge, right now, Mr. Johnson is speaking to him. He's basically financially indigent. At this time, he did inform me he is homeless. He's from Pennsylvania. He has family there. My understanding is he came down to South Florida for recovery. Judge, he's not in a position to post any sort of financial bond. My understanding is he does have family that care about him, specifically his mother. My understanding in speaking with Mr. Johnson.
His mom is watching us right now, actually, Judge.
Oh, okay. I'm right now viewing it. My understanding is she would be the only one that could probably help him out financially with a monetary bond. But in speaking with Mr. Johnson, from what he informed me, she is a teacher, so unfortunately, teachers aren't paid what they're worth, so my understanding is probably their financial resources are limited. Judge, but as I said, Mr. Johnson at this time is not working, so he cannot post any sort of financial bond. And he did inform me as far as regarding this incident, he wanted to go ahead and go into the facts and details, but I told him today's not the day. He is denying the allegations, and he is basically adamant he wants his day in court regarding this incident.
Okay.
Mom is probably not going to be a lot of help as far as posting bond is concerned. Is that correct? She doesn't have the money, Judge. I'm on the phone with her right now. She just doesn't have the money to post that kind of bond.
All right, this time I am going to impose a finding probable cause for attempted robbery, $7,500 bond, no victim contact, and Mr. Johnson, if he posts this bond, will also be on a level 2 pretrial, $7,500. Okay? No possession of any weapons or firearms. Okay. All right, Iris Espada, the Spanish interpreter, is here. All right, Ms. Espada,
Señora Espada,
you are before the court today
está usted acá ante la corte hoy
for one count of petty theft,
por un cargo de hurto menor.
and the court finds probable cause,
La corte encuentra causa probable para el delito.
and I will hear from the parties as to bond.
A ver cuál es la fianza.
Does Ms. Espada have any priors?
I'm not showing,
Si usted tiene antecedentes, están viendo.
I'm not showing anything.
All right.
Judge, I tried to speak with her earlier this morning.
Dice su abogado que él trató de hablar con usted más temprano hoy día, en la mañana.
And we were able to talk a little bit.
Pudieron hablar un poco.
But I felt that, and she agreed, an interpreter would be appropriate.
Y usted estuvo de acuerdo que sería mejor con un intérprete.
So I haven't really talked to her about how she would like to address the situation this morning.
Entonces yo realmente no he hablado con usted sobre cómo quiere usted arreglar la situación de hoy en la mañana.
So I don't know if she wants to try and resolve the case today.
No sabe si usted quiere resolver el caso hoy mismo.
And I don't know what the offer might be from the state.
Y no sabría decirle a usted cuál sería la oferta de la fiscalía en este caso. Yes, I do want to resolve.
You know, it looks like all the items were retrieved.
Parece ser que todos los artículos fueron regresados a la tienda.
If that is correct?
Es correcto, yes.
Sí, es correcto.
Yes, it's correct.
Will the state be able to make an offer?
Está preguntándole al señor fiscal si le puede extender una oferta a usted para todo su caso.
No, I'm not asking you, ma'am.
No le está preguntando a usted.
Okay?
Your Honor, she wants a plea. The offer is a withhold court cost. I don't know if.
La oferta es una retención de la condena y costo de corte si usted quiere declararse culpable.
And if the court would want to ROR her, she might be eligible for a diversion program.
si la corte, la jueza le quiere dar la libertad bajo palabra, usted podría ser elegible para un programa de diversificación judicial.
All right, I'll ROR Mr.
Le
Espada
va a
at this
dar la
time.
libertad bajo palabra, señor.
Thank you, Judge.
Okay?
Thank you, Mr. Linder.
All right, good luck.
Que tenga buena suerte. Thank you.
Thank you. You forgot about
You
us?
forgot about us. We're so hurt.
No, I don't